Free speech, a First Amendment right, and the topic of the day as we head into oral arguments at the United States Supreme Court in the case of Chiles v. Salazar. I'm Andrew Spangenberg, Director of Allied Legal Affairs at Alliance Defending Freedom, and I have two very special guests with me today to talk through this blockbuster case at the U.S. Supreme Court, a case where a Colorado law censors counselor speech and prohibits certain private client-counselor conversations regarding sexual orientation and gender identity. I'm joined today by ADF's client, Kaley Chiles, a counselor. I'm also joined by the Supreme Court advocate, Jim Campbell. Kaley is a licensed professional counselor in Colorado, and she's a committed Christian who seeks to live out her faith in every aspect of her life, including her work. Jim is the chief legal counsel at Alliance Defending Freedom, where he leads our U.S. legal advocacy team. Kaley, Jim, thank you so much for joining me.
Thanks for having us.
Thanks for having us.
Now, before we jump into the facts, Kaley, we want to hear your story. Jim, we want to hear about the law. Let me underscore the critical importance of this case. It's about free speech. Benjamin Franklin said, whoever would overthrow the liberty of a nation must begin by subduing the freeness of speech. And potentially more on point is Frederick Douglass, who said this: to suppress free speech is a double wrong. It violates the rights of the hearer as well as that of the speaker. I think the application is pretty clear. Kaley, it violates a counselor's speech, but also your client's rights who want to hear that speech. All right, so let's dive into this case. I think we need to start with who the parties are. We have one of the parties on with us, Kaley. Jim, who's the other party? I'll lob that question to you.
So the other side of this case is essentially the state of Colorado. They're the government officials that enforce the law that is trying to silence Kaley and what she says to her clients.
And if we could summarize this case real quick, again, just to kind of get our bearings, give us a high-level overview, like a 20-second quick snippet of what this case is. Jim, I'll lob that back to you again.
So the bottom line in this case is whether counselors and their clients should be able to determine what they want to talk about and what goals they want to pursue, or whether the government should be able to come into those private conversations and to tell the counselor and the client that there are just certain views that you cannot discuss. We think it's very clear that the First Amendment protects those counseling conversations, and we're hopeful that the Supreme Court will agree with us.
And Kaley, tell us a little bit about yourself. Why did you become a counselor? What do you love about it?
Well, there's lots to love in counseling. I think what drew me to it initially is that everything is an investment of your resources. And in counseling, when you invest in your own personal growth, that's not something that can rust or decay or be taken from you. And I really love that security of it, that you get to invest and it's going to be a good investment.
Yeah, good investment. I love that. Can you tell us a little bit more about your background? Where'd you go to school?
Yeah, well, my bachelor's degree is from Dallas Baptist University in Biblical Studies, and my graduate degree is in clinical mental health from Denver Seminary. And right now I'm working at Deeper Stories Counseling in Colorado Springs.
And when these clients come to you, do you have a predetermined end goal for them, or do you seek that goal together? Do you listen to them? I mean, how do you approach those conversations when they come to you?
Great question. When clients come to me, they seek me out and they approach me, and we have a conversation where they tell me, here's what brought me to counseling. Here's the problems I'm experiencing. Maybe I have some goals that I'd like to achieve for myself. And then I, as their counselor, talk with them about how I think I might be helpful. And we decide together if we think we might be a good fit and if we'd like to move forward and think that we might reasonably be able to make progress.
So their objective's important to you, it sounds like.
Of course.
Kaley, these conversations, you've had these conversations in the past. You currently want to have them. Is that true? And then you can't because of this law. Is that how I understand it correctly?
You got it. Yeah. Talking with teenagers in counseling, it's not very uncommon for them to want to talk about things like sex and sexuality. And especially as Christians, we believe that we are embodied souls. And so that's an important topic, not just to our body, but also to our soul. And so minors, obviously, as they're forming and building their identities, they want to be able to talk about these topics.
Let's switch a little bit to the legal side, Jim. And I think first, let's start with what law is at issue. We talked about it already, but let me hear the legal side of it. What is the law at issue?
Yeah, so the law at issue is what we call a counseling restriction. The state of Colorado used the term conversion therapy, but it's a really deceptive term because the state has defined what's prohibited so broadly. What the state's essentially said is that if any client who's a minor, wants to work with a counselor and wants to achieve a goal involving change on anything touching on sexual orientation or gender identity, whether that's someone's identity or their attractions or their behaviors or their expressions. You can't pursue change, even if that's the client's goal, unless it's a gender transition. That's the one exception in the rule. And so that's just a really far reaching law, and it shuts down really important conversations that young people want to have with counselors like Kaley. But unfortunately, the state of Colorado is sticking its nose in those conversations and saying what can and cannot be said.
And it's sticking its feet in the ground, right? Not moving. So there's no way that I'm going to assume there's no way that this implicates just counselors. Am I right on that, Jim? I mean, what other professions could potentially be implicated here? Should the court go one way or the other?
Well, the state of Colorado makes a pretty broad argument. They argue that free speech rights should be stripped away from a class of professionals. And the factors that they identify are people who act based on expert knowledge and have individualized personal discussions with clients. And it doesn't take a lot of imagination to realize that that could apply to lawyers. And so, what's next? Is the government going to come in and tell lawyers that if you have a client that comes in and wants to talk about an issue, you can advise them one way, but you can't advise them another way? That same kind of standard could also apply to people in the financial industry, to accountants. There's really no end in sight. If the government can come in and say, simply because it has labeled you a professional, it can now tell you what you can and cannot say to clients.
You got me on the lawyer part. You and I both lawyers. It sounds like we could be in danger here, which is super compelling for me. All right, Jim. Key legal issue. Okay, we're going to the Supreme Court here. We're going to have oral argument. And we heard from Kaley just now. Let's say the justice has heard that story and they say, wow, I'm very sympathetic. I want to rule in her favor. That's not enough. What is the legal ground for the justices to hang their hat on and say, this is why you win?
Bottom line is the First Amendment, and the First Amendment has various rights that it protects, and the one that's most directly at issue here is freedom of speech. So a counselor's conversations with their clients are protected by the First Amendment. And when the government comes in and says that you can speak one view on a particular topic, but you can't speak a different view on that topic, that's classic what's known as viewpoint discrimination. And the Supreme Court has said time and time again that that's problematic under the First Amendment.
Kaley, are you using words or are these conduct? Is this conduct? I have to ask it. I mean, that's what's at issue here. Are you having conversations?
Yeah, when a client comes to my office, especially for issues like these, then we have a conversation.
No. Wow. I think we just won the case, right? We got to go a little bit further than that. I want to give our audience a little bit of a roadmap of what they might hear at oral argument. Maybe just hit on a few buzzwords, some important key concepts. I mean, Jim, I think you summed it up very well. It's free speech, but as far as the law goes, it's maybe a little bit other. There's a few more pieces to that. So it's free speech. Let's assume the other side is saying it's not speech. Is that right, Jim?
It's absolutely speech. And the Supreme Court has recognized that speech, a conversation, qualifies as First Amendment protected speech. Specifically, the Supreme Court has said that in the context of conversations between attorneys and their clients. And there's no reason why a counselor and her client should be treated any differently.
So we've got speech, and assuming it is speech, which is a First Amendment right, then you mentioned viewpoint and content restrictions. And that's important. Let's say that it is a viewpoint discrimination or a restriction. What kind of scrutiny is the court going to use here? And it's going to be important for why the district court went one way, why the 10th Circuit went one way. What are we asking the Supreme Court to do here? What level of scrutiny are we asking them to use in evaluating this case?
Whenever the government is picking and choosing views that are okay and views that are not okay, the Supreme Court applies what's known as strict scrutiny, which just places a really significant burden on the government to come in and say that it has a really, really good reason to do what it's doing. The problem for the state of Colorado in this case is that its own expert materials that it filed trying to justify its law actually undermines it. And what I mean by that is their own expert materials acknowledge that there's no evidence that what Kaley wants to do, these loving, caring conversations she wants to have with kids, that those actually cause harm. In fact, the state's own materials show that many people experience life changing benefits from those kinds of conversations. And so at the end of the day, the state of Colorado simply doesn't have support to try to shut down what it is that Kaley wants to do in coming alongside these kids and helping them walk down a difficult road and reach a place where they ultimately find happiness and peace.
I'm glad you mentioned that, Jim. As I was reading the briefs, they talked a lot, both sides talked a lot about what's called a compelling state interest, and that falls under the strict scrutiny bucket, and whether or not this causes harm. And what is the scientific evidence on it? And both sides talk about that. And I think you hit the nail on the head that there is no harm. In fact, like you said, the harm goes the other way. Is that right? The harm goes the other way. If we actually enforce this law, kids are harmed. Why is that?
Well, it's absolutely the case because it doesn't take a very significant amount of perception in our society to realize that young kids are struggling with issues like sexuality and gender, confusion about who they are, discomfort with their body. And what the state of Colorado has told licensed counselors is that if a kid comes in and is struggling with how they identify and discomfort with their body, the law specifically says you can lead them down the path of a so-called gender transition, but you can't help them to go in the other direction. And so what is a counselor going to do in the state of Colorado? If they're concerned about their license, they now have pressure to lead kids down the path of transition, which so much evidence is showing us is not in their best interest. And so what Colorado is doing is actually harming these kids that simply need a voice like Kaley's to be able to sit down and walk them through what they're experiencing and help them to realize that they truly are made fearfully and wonderfully, and that their body is something that they should cherish, not something they should reject.
You touched on at a point that the state's brief makes. Let me kind of highlight that. It says that this is a standard of professional care that the law that they're enforcing or trying to. It's a standard of professional care that patients have a right to expect. Kaley, when your clients come to you, I mean, what are they expecting? Are they expecting what the state says they should be expecting, or are they coming to you because of their religious belief?
Well, my clients come to me probably from all kinds of different locations that I'm not even aware of, but a lot of them do come to me and express that they're here because they're aware that I'm a Christian and they themselves are Christians, and they do believe that their identity starts with being a child of God and being created and made in the image and likeness of God. And from there, we all experience a variety of different struggles because we live in a fallen world. And so people are wanting to wrap their minds around how can these things be true and how can these feelings exist all inside of me all at once. And they need help. They want help kind of untangling that confusing situation and not having certain forbidden goals that they're not allowed to make and state endorsed goals that they are allowed to make at the outset.
All right, Jim, real quick, let's talk about this idea of medical malpractice and professional practice laws that the state makes a big to-do about. Why do they make a big to-do about it, and what's your position on that?
Well, the state is trying to make a point that if Kaley wins this case, that it's going to have impacts elsewhere. And I think that's just simply not true for a number of reasons. The first point that's really critical is that the state of Colorado has pointed to no other law like the one it's trying to defend. There's no other law that we've identified, that the state of Colorado has identified, where the government has gone in and shut down voluntary counseling conversations simply because of the view that the counselor and the clients want to express and explore. And so when we understand that, then we know that striking down this outlier law and indicating that it violates the First Amendment is not going to have an impact on other laws and other circumstances where the government might need to regulate licensed professionals. And so at the end of the day, we think that the state hasn't made any arguments that are effective along those lines. And the reality is that this law just shuts down good people from having caring conversations and helping struggling kids at a time when they need it.
Man, that part's compelling. Good people trying to have caring conversation with these kids. All right, now look, this isn't the first time we're going to court on this case. There was 2 lower court opinions or decisions. There's a district court level where the first stop, and then the second stop was at the 10th Circuit. Why are we here at the Supreme Court? What happened below, Jim?
The lower courts just got it wrong. They really downplayed the First Amendment implications of what's going on here. Now, the one good thing about those 2 lower court decisions is they did recognize that Kaley does have legal standing to challenge the law that's in front of us today. And that's something that Colorado argued on the other side. They tried to suggest that Kaley really doesn't have standing and she shouldn't be in front of the Supreme Court. But the 2 lower courts disagreed with Colorado on that. But the point where the 2 lower courts got it wrong is that they really downplayed the First Amendment implications. And they gave the state of Colorado a blank check to go into the counseling room and to tell people what it is they can and cannot discuss and which goals they can and cannot pursue. And that's something that the First Amendment won't stand by and allow to happen.
But at least 4 justices of the United States Supreme Court thought this was worth taking up. I mean, the chances of a case getting granted what's called certiorari by the Supreme Court is pretty limited. Jim, what's the number now? Like, how many petitions or for cert does the Supreme Court get a year? Is it somewhere around 10,000?
I believe the court gets somewhere between 6 to 8 to 10,000 every year, and the court currently is taking about 55 to 65 cases a year. So the odds of getting the Supreme Court to take a case are a little less than 1%.
Which just highlights and underscores the importance of this case and free speech. Kaley, we really appreciate you taking the stand that you're taking. And Jim, we really appreciate you going before the United States Supreme Court and arguing her case. And we also thank the audience for joining us today and listening. That's all the time we have for today. But we appreciate you tuning in, and tune in next time because we have several more Supreme Court cases coming up. Thank you.